This video will examine the facts and holdings of Azuko Pty Ltd and Old Digger Pty Ltd and the significance of the judgment with regard to the different approaches to the issue of secret use in patent law. In this case, the original proceedings were brought by Old Digger, who claimed that Azuko had infringed two of Digger's patents relating to percussive hammers used in drilling equipment for exploration purposes in mining industries. Azuko denied the claims and brought a counterclaim for the revocation of the patents on the basis that there had been secret use by the patentee, Mr. Gill, prior to the priority date. The priority date being the date at which the novelty and inventiveness of the invention are assessed against the prior art base. This is usually the date the patent application is filed. The facts of the case are as follows. The patentee had manufactured 15 to 20 examples of the hammer with the intention to sell them. The patentee had received an order from a reputable customer ready to purchase on or around the time of manufacture, although no sale had actually taken place before the priority dates. Azuko claimed that this manufacture before the priority date amounted to secret use, therefore invalidating the patent. In the original proceedings, His Honour Justice von Dowser held that there had not been a commercial use of the invention and that the use was confidential, thus the case for revocation was not successful. Azuko appealed this decision where Justices Beaumont and Giles, by majority, upheld Justice von Dowser's decision, with Justice Heery dissenting. In its judgment, the court considered the meaning of secret use. Section 18 of the Act provides the requirements of a patentable invention for a standard patent. Specifically, Section 18, Subsection 1, Paragraph D provides that an invention is a patentable invention for the purposes of a standard patent if the invention was not secretly used in the patent area before the priority date. Justice Heery stated that the historical rationale was to prevent a patentee from gaining a longer monopoly than the statutory period by enjoying a period of de facto monopoly through secret use without meeting the corresponding obligation of public disclosure. Essentially, the rationale of the patent system is considered that the monopoly is granted in exchange for disclosure of the information about how to perform and use the invention to the public. The concept of prior secret use undermines the balance. His Honour Justice Giles held that the use by Mr. Gill's manufacture of the hammers was not a use of the invention, as there had been no commercial benefit. Further, His Honour makes the distinction between the process and the product claims, expressing that the manufacture of goods is not commercial use of those goods. In comparison, Justice Heery clarified that the terms use, secret use, and secretly used are not defined in the Act. However, the conferred rights by a patent are exclusive rights, which include the right to exploit the invention in accordance with Section 13, Subsection 1 of the Act. The definition of exploit being contained in Schedule 1 includes the following: where the invention is a product, make, hire, sell, or otherwise dispose of the product, offer to make, hire, sell, or otherwise dispose of it, use or import it, or keep it for the purpose of doing any of those things. Where the invention is a method or process, use the method or process or do any act mentioned in paragraph A in respect of a product resulting from such use. Justice Heery argued that Mr. Gill's intention to sell the hammers once the priority date arrived means the production of the invention was already underway. Therefore, the commercial benefit Mr. Gill obtained was not a tangible financial benefit, but more of an indirect benefit due to having prototypes already ready for sale. He held that this type of use amounted to secret use. In the end, the majority's decision stated that an unsolicited order is not use or obtaining a commercial benefit, and upheld the initial judgment from His Honour Justice von Dowser.